The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Three cases will be submitted this afternoon. Those cases are Pamela Plowman and Jeremy Plowman versus Fort Madison Community Hospital and others. The second case is Iowa Supreme Court Attorney Disciplinary Board versus Tarek Kawasak. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Brian Green. The last case is submitted to the court at this time without oral argument, and will proceed to hear the arguments in the first case. Mr. Willoughby.
Mr. Chief Justice, pardon me, members of the court. May it please the court, my name is Wayne Willoughby, and I'm here to argue on behalf of the appellant. In this case, the appellants, Mr. and Mrs. Plowman. I think it's important at this point that I discuss with you what is not before the court today. What is not before the court today is the morality of abortion. That is not an issue before this court because Roe versus Wade declared the family's right to seek an abortion if they choose. Not before this court is a public policy favoring life over abortion. The Iowa Code allows abortion up through the second trimester, 26 weeks.
Wait, if we're going to talk about that issue, I mean, if we're talking about public policy as made by the Iowa legislature, the legislation that was on the books prior to Roe versus Wade did outlaw abortion in most circumstances. Isn't that correct?
I'm not familiar with the law prior to Roe versus Wade. I do know, however, that the statutory code now, the penal code on feticide, does not prohibit or criminalize or in any way punish abortion up through the second trimester.
If this case, counsel, if this case went to trial, would you be entitled to strike any prospective juror for cause who said they were pro-life? Because your theory is that the plaintiffs, the parents, would have aborted had they been better informed of the results of the ultrasound. So doesn't the jury have to find that this child never would have been born?
What they have to find is an issue of credibility. The parents are going to testify that had they been properly informed, had the doctors met the standard of care that their own profession applies to them as medical doctors, that they would have elected to terminate this pregnancy. So yes, as a matter of causation, they would have to determine that the family would indeed terminate this pregnancy had the doctors met the standard of care.
I mean, to follow up on Justice Waterman's question, if one spins out the facts, if this court were to recognize the cause of action that you want the court to recognize, then you'd have a trial, right? And yes. Then you pick a jury, and there are a number of Iowans out there who are probably probably opposed to an abortion in the circumstances described in this case. Would you be able to strike those Iowans for cause from the jury panel?
I would certainly make that argument, and I'd also note that in the 19 or so states, the 22 or 24 states where this is allowed, that apparently has not been a problem because I've not read any cases where courts were unable to find a jury pool to hear a wrongful birth, what is styled a wrongful birth action, but what in reality is nothing more than an adaptation or of medical malpractice law to a specific set of facts. Also not before this court is any wild claims of this will lead to eugenics or the value of human life and all of these things, because if this court is to find that a physician must honor the standard of care that his or her profession establishes for the conduct of prenatal testing and conveying the information of prenatal testing to the patient, and vindicate that right in favor of the patient and the husband, then it's not a matter of causing more abortions. It's a matter of informing parents at a point in time when they can make that very difficult personal choice, whether to continue a pregnancy or not. It's not going to lead to more abortions or less abortions. What it's going to lead to is doctors being more careful about adhering to the standard of care and providing to their patients and their husbands the very information that an ultrasound and other prenatal testing is supposed to convey.
You mentioned the patient and her husband. If they disagree, isn't it the mother has the right to choose whether to have the abortion constitutionally? If the husband, and the husband is not the patient, does the husband have a right to sue under your theory?
Under my theory, the husband does have a right to sue as well. The issue is one of parental choice as well as the mother's choice. In the family situation, the husband and wife typically make these decisions together, and the physician understands that. When they're counseling a married couple or a couple that's together, that the information that they're providing is not only informing the mother, but is also informing the father, so they can make this choice. Ultimately, the woman has the final choice, but wouldn't you want to encourage the two to share the choice together as much as possible?
Are you making a claim on behalf of the child, their son, Z?
No, Your Honor.
Is that because nearly all the states have considered the issue, have held that no claim can be brought on behalf of the child because they won't say no life is better than a disabled life?
That's what the cases say predominantly, with a couple exceptions, that we're not to that point, nor are we asking this court to go to the point of finding an action on behalf of the child. The child is not injured when looking from the child's perspective. The child is alive. The injury here are to the parents who, because of the negligence of their physicians, were denied the opportunity to make an informed decision whether to continue with the pregnancy that would end up producing a child that is severely brain damaged, cerebral palsy, multiple seizures every day, blind, can't speak, can't walk, and to assume willingly, if they so choose, to incur the huge financial burden of caring for this child, as well as the huge emotional burden of caring for this child.
This may be a good test case. Can you address my concern about the cases that may follow where it's a less severe disability? Let's say it's just they're going to be mildly disabled.
Your Honor, Roe v. Wade, whether you like it or not, and we each have our own personal views on that, some grounded in our religion, some grounded in our personal morality. But the law of the land is a woman may have an abortion for a good reason, bad reason, or no reason. So, respectfully, I think looking at it in terms of what if the injury is less severe is missing the point. The right being vindicated here is a medical malpractice right to be properly informed by your doctor. The fact that an injury is severe or not is irrelevant to the right that the standard of care establishes in the medical profession and the law allows through medical malpractice claims.
By your logic, wouldn't that apply to, say, a wrongful prolonging of life claim? What if you had a situation where somebody came to the doctor and said, our parent is we think they're going to die and they're having a poor quality of life, and we don't, and we have medical power of attorney, and we don't want them you to take superhuman procedures to save their lives, and then it turned out that the doctor, say, disobeyed the instructions or did something that was, in your view, negligent. Could they sue in that circumstance?
No, I believe one of the cases cited in the briefs, and forgive me, I'm drawing a blank on the name, dealt with a situation along those lines where a mother, or rather a wife, did not want to continue wanted to continue life-sustaining care to her husband, but it was terminated. There was some confusion about whether she'd given written consent or not. And the doctor, for whatever reason, terminated life support, and the patient died, and the wife attempted to sue. In that case, the duty ran to the patient, the court found, and not to the surviving spouse. There are statutes in Iowa and elsewhere that deal with who can make these decisions on behalf of the patient, but in terms of bringing a lawsuit, no, the person wouldn't be able to bring a lawsuit for themselves. The injury was to the patient whose life was prolonged contrary to their wishes.
Why would, but what if there's a situation where, let's say, there's a guardian, or let's say, could the estate of the patient sue under those circumstances?
Applying medical malpractice. I hadn't given this much thought on that aspect, Your Honor, and I'm being honest about it. I would think not, because you're talking about suing for having someone prolong your life. I don't know, Your Honor. I simply don't know. I'd have to think it through. I could see a straight medical malpractice application where a case would exist, but I'm not prepared to deal with the implications now. I'm sorry.
So how many states recognize this cause of action?
By my count, 24, I believe, and I think by their count, 22. Some of them, most of them bring it up and say that Roe versus Wade creates the right, so that what's being sought here is nothing that's contrary to law or contrary to policy. A woman has a right to terminate a pregnancy, so that shouldn't be any impediment to bringing the action. That's the view of the cases that are viewing this as a medical malpractice action, and same as any other, just different fact pattern.
So what do you say to a judge who's very pro-life and just thinks Roe versus Wade should be overturned? What do you say to them?
I'd respectfully say that there are things in this world that we all like or dislike on a personal level, a moral level, or a philosophical level. But the Supreme Court of the United States has established the law that applies. And our job as members of the court, bench, bar, is to apply the law. And although you personally disfavor abortion and think it is wrong, the Supreme Court of the United States says you must put that aside. It's not your decision. As long as that's the law of the land, it's the wife, it's the parent's decision, it's the woman's decision.
Supreme Court doesn't require us to create this tort, right? Roe versus Wade does not require the establishment of this tort, does it?
Roe versus Wade does not require establishing any tort, and I argue that you're not establishing a tort. The tort is established. It's called medical malpractice. It involves a duty, a breach, causation, and an injury. We have all those here. What we have is an application of medical malpractice just to a different set of facts than typically come across the threshold of the courthouse.
This is a question of first impression here. We haven't had this type of case. The closest we have is the Nonke case, where we held you could not sue for the birth of a healthy child. Does the reasoning of that case stand in your way?
No, Your Honor, it does not, and here's why. The reasoning of that case was that the parties were trying to obtain compensation for having given birth to a healthy, normal child, when this court determined that the value of parenthood of a healthy, normal child far outweighs the economic costs. In our case, we're not dealing with a healthy, normal child. My clients are never going to watch their child walk. My clients are never going to watch their child communicate normally. They're never going to have the hug. They're never going to have the benefit of watching their child get married and have more children. They're never going to be able to use his services. He's never going to be an active member of the family. That materially distinguishes our case from the other case. And the court even said in Nonke that they were very narrowly focused on the facts of the case. We present what was not before the court there. And an instance where one cannot say that the benefits of parenthood far outweigh the extraordinary costs of caring for this child. A couple other things that are not before the court. Defensive medicine is not before the court, because all we're doing is say, follow the standard of care, do the job that your profession expects of you, and convey the information to the client the way your profession expects of you. You don't have to order any extra tests. You're not being asked to recommend abortion. Doctors don't recommend abortion. They provide information to patients who make decisions. You have an opportunity to go and vindicate that right of all patients, including patients who are receiving prenatal counseling, to obtain standard of care testing and standard of care information from their doctors.
Has there been any other situations where courts have excused a doctor from providing pertinent information, medical information?
I'm trying to think through all the cases. There are a few cases that are noted in the defendant's brief which have found no cause of action, those. But the only other instance I can think of where a doctor is not held responsible for conveying information to a patient falls in the area of psychiatric care, when the doctor makes a determination that the patient simply can't handle the information. They are psychologically or psychiatrically too unbalanced or fragile. And I think in those instances there have not been liability attached. But that, of course, is not our case. What we have is a garden variety medical malpractice case, in the sense that a patient went to doctors seeking testing and information, and the testing was not properly, the information from the tests were not properly conveyed to the patient. So the question I think, respectfully, you have to ask is this the type of professional conduct that we in the state of Iowa want to condone? Do we want to grant immunity and immunize this conduct and say that among all the other conduct the physicians are responsible for doing according to the way they were trained? Do we want to carve out a spot here and say, no, It's okay in the area of prenatal testing for you to be negligent. It's okay to substitute your judgment for the patient's if you want to, because we're not going to hold you responsible when you either sloppily or intentionally do not pass on the information that would allow a woman and her husband to make an informed choice whether to incur knowingly the extraordinary burden of caring for a child such as our client's child. Something else that's not before the court.
You may sum up, Mr. Willoughby.
Thank you. I think that I pretty much laid it out the way that I view it. This is a medical malpractice case. You're not saying abortion is right or wrong. You're not saying anything about it except that the law of the land is that the parents get to make the choice. And we don't like malpractice in our state. We're not going to countenance malpractice. We're not going to tell doctors that, okay, you can be sloppy, you can be negligent, and there's no accountability for it. Thank you, Your Honor.
Thank you as well. Ms. Penner.
May it please the court, counsel, my name's Nancy Penner and I'm here on behalf of defendants. We are not here with an argument to skirt responsibility or liability in this case. This case was dismissed just approximately 2 months before trial, and the defendants were fully prepared to defend on the merits. We are here because plaintiff's case represents a substantial departure from what plaintiff's counsel articulated as a run-of-the-mill or garden variety medical malpractice case. We disagree with that. We believe there are substantial departures from their case from a typical medical malpractice case. And we request the court to fully consider all of the issues presented in the briefs, including the public policy ones. And we submit that at the end of that analysis, the court that it will decide that it's for the Iowa legislature to decide if Iowa is going to recognize this cause of action. And if not, we request that the court deny the cause of action.
How does the constitutional right stack up against the public policy?
Your Honor, this case is not about balancing a woman's right to choose against the right of an unborn fetus. This case is about a born child, a live child. We think that that changes and heightens the public policy for this court to consider. This isn't about balancing parental or maternal rights, constitutional rights. The child's here. And this is about the state's public policy. And Nancy, we believe that public policy does apply to this court, this case, and that before this cause of action is recognized, the court has to grapple with whether the public policy announced in the wrongful pregnancy case can really be pushed aside for this case.
Is Nancy really binding on us? I mean, it was a majority opinion. There were only 4 justices who decided the case with 1 dissenting, and there was a 9-member court. And as I understand the law on majority opinions, it may be binding on lower courts, but it's not binding on a full panel of the court.
Your Honor, I would, for one thing, Nancy is a different case. It is a wrongful pregnancy case, and I believe, I have to be honest, that I think the court can deny the cause of action in this case without overturning Nancy. Okay, so I think the court needs to.
I'm just concerned of its presidential value, because it was decided by a less than a majority court, and you know, we're not bound, as I understand the law on majority opinions, a full court's not bound by a majority opinion.
I won't disagree with your analysis of the law, that law, but maybe.
My question was going to be, are we bound by any of our precedents?
I think not, except I would draw the court's attention to Rule 1.206. And that rule, or formerly Rule 8, that many of us are familiar with, sets forth what we believe are the parameters of the parental right to recover. And the vast majority of plaintiff's damages in this case and in all these wrongful birth cases are the medical expenses incurred to care for their minor children, and those are Rule 1.206 damages. Plaintiffs agree that they aren't bringing a Rule 1.206 claim. That's because they're seeking damages beyond the age of 18, and they do not claim that this physician caused any injury for the child. The child's condition is a result of apparently what the child inherited from parents, not the negligence. Plaintiffs
Let me just interrupt for a question, and I'm going to diverge a little bit from that as well, just because it's on my mind. You know, we talk about leaving it to the legislature to determine whether there's some type of cause of action, but in a review of all the cases and all the states that have actually recognized this, I mean, can you give me a breakdown? I'm just going through my quick little review of the briefs and things, but it seemed to me like the vast majority of those that do recognize it has been created by the court and not by some legislative. And maybe there's 2 or 3 states that actually, through legislative action, recognize the cause of action. But again, the vast majority are been created through the actions of a court, like we're going to attempt to do today.
Your Honor, I agree. The research, our research, and consistent with plaintiffs, is the majority of states that recognize the cause of action, it has been recognized at common law. 11 states have banned the cause of action legislatively, which we think speaks to the public policy issues here. But I will say that the cases that I read for across the country, they do not talk about a statute and a rule like Rule 1.206. That hasn't been raised. I think that distinguishes Iowa. And we know of no way for parents to recover medical expenses in Iowa other than Rule 1.206.
Rule 1.206 says resulting from injury to the death of a minor child, and the extraordinary expenses from a healthy child can be construed resulting from the injury to the death of a minor child. I mean, why is that logic wrong?
Your Honor, the way I would answer that is when the Rule 8, Rule 1.206 cases talk about defining the parameters of parental recovery. They talk about who the cause of action for medical expenses belong to. They talk in terms, and this court has steadfastly refused to expand the recovery set forth in rule. We submit that medical expenses for a minor child, I don't know of any other basis to bring, and even if the court determines this isn't a Rule 1.206 claim, and to be honest, we agree, it's not. They can't fit it in there.
To accept your premise, though, I think we have to say that there is no damages because there's going to be no damages for the birth of any living child, and so the resulting language doesn't mean anything. I mean, that's the only way I can see your argument squares with writing out the resulting language.
And several states have gone that route, and plaintiffs carefully articulated injury in this case. They avoid articulating the injury as the existence of the child because that brings them too close to the wrongful life cases that everybody disallows, almost everybody disallows. So they articulate their injury as the loss of choice to terminate the pregnancy. Ohio and Oklahoma have said they recognize parts, and we do too, parts of this claim are medical malpractice there is medical malpractice allegations, but the injury and the damages that would flow from recognizing the cause of action, but without the extra, what we believe are unrecoverable damages, would be the damages of going through with the pregnancy and childbirth as compared to termination. Plaintiffs have
Don't
asked
the
for that.
parents have a legal right or legal obligation to support the minor child, which would include paying the child's medical expenses, right?
And they do, but if that supported the cause of action, that would have supported a different result in Nanke, because parents are obligated to provide the ordinary expenses to raise their children too, and that didn't stop this court from
But
rejecting that.
Nanke didn't say that, if it's presidential, but Nanke didn't say there were no damages. Nanke said there were damages, and raising the child is a cost to those parents, but for public policy reasons, the joys and other benefits of having a healthy child offset those costs. And that's different than what you're arguing.
And Nanke, I understand what you're saying, that Nanke was only, it was a narrow issue. It was only about whether they can recover the ordinary cost. The other part of the claim was not at issue before the court.
If you read Justice Woolley's dissent, he said, let's let ordinary tort law do it for healthy kids. And the court, I think, was very specific that the benefits of a healthy kid or child outweighed any damages you can have. And they said, we're not going to comment on a child with a disability.
And I understand what the Justice, you're saying about what the dissent in Nanke said. And this court often takes things and limits ordinary tort principles. The Nanke case is one example of that, but there are other examples. The Waite case cited in our opinion says physicians are not responsible for damages they did not cause, and they don't allow them to be responsible for that. Every negligence does not create a cause of action. The Engstrom case cited in our case was about a failed adoption, and that cause of action against the social worker was not recognized. So just because
How do you respond to the argument that Mr. Willoughby made it very articulately, that the rule that you advocate for would reduce the incentives for, say, a radiologist in this case to do their job properly?
I don't believe that it takes the threat of litigation for physicians and other professionals to provide care within the reasonable standard of care. I think that they're held to professional, ethical, and moral standards of their profession that provides incentive for them to provide adequate care.
Well, Counsel, are you suggesting that the role of deterrence in our tort law doesn't apply in the medical field?
No,
Okay.
I'm not. But of all the public policy things that are at issue in this case, that is one. But there are many others, and I bring the court back to the fact that plaintiffs distinguish the wrongful pregnancy cases and the normal healthy children public policy by talking about the severity of the child, of the disability of the child in this case, and I think particularly with the advent of the ADA, which was passed after many of the common law cases recognizing this cause of action were passed, that there's another really strong public policy interest that the state of Iowa has in the rights of the disabled community. And these cases are in no way limited to severe disability. There are, and we're not making that up. There are examples cited in our brief from other jurisdictions where the only disability is blindness. The only disability might be a deaf child, and I'm not minimizing those disabilities, but those children are fully aware to understand the litigation. The other members of the people in our society who are disabled are fully able to understand that, and it sends a very troubling message to society as a large that I don't think that this court should or can ignore. And that is another point that distinguishes this case from the other cases across the country that have recognized the cause of action. They do not talk about disability rights very often. There are a few that do, but it is of more recent. It is more recent because of the ADA and in our society, and it may explain why it's not talked about. But it's real, and it's something we believe the court must consider. And in summary, we believe the cause of action should be deferred to the Iowa legislature. Rule 1.206 has a long history in Iowa. Like I said, we know of no other way for parents to recover medical expenses other than that rule. And this case doesn't fit. And when the legislature has spoken about the parameters of a scope of recovery, we think that the legislature should expand that, if anybody. We had additionally cite the court to the public policy opinion and the many issues and the many dissimilarities between this case and a routine medical malpractice case, as we've discussed in our brief. My time is about up, so thank you.
Ms. Penner, thank you as well. Mr. Willoughby, you may present your rebuttal.
Thank you, Your Honor. In essence, the argument for the allegedly negligent doctors is that this court should shirk its role to enforce medical malpractice laws, should ignore a child who is devastatingly injured and the burden that is placed on this family because the doctors failed to provide mom and dad with what they were contractually, morally, ethically, legally, and professionally obligated to do, information that would allow them to make an informed decision whether to continue.
Isn't Ms. Penner right? I mean, there are a lot of instances where people can't be sued. I mean, I could, and I have made certainly mistakes in decisions that I've written, and I can't be sued over those mistakes. I mean, not every single breach of a duty results in a cause of action, does it?
With the exception of the psychiatric injuries I was talking about, where a doctor makes a judgment call not to inform a patient, I'm unaware in the area of medical malpractice where a doctor is immunized by judicial opinion from committing malpractice. Even in the case referred to by the defense involving a social worker being sued by parents whose adoption fell through, that case noted that their holding did not apply to situations where medical care was being provided by a clinical social worker and psychotherapy or anything else. The purpose of tort law was brought forth by justice include compensation, deterrence, and encouragement. Deter bad behavior, encourage good behavior. Especially,
Counsel, could you address the defendant's argument that our Rule 1.206 precludes recovery, that is through that rule, that occupies the field or is the exclusive vehicle for a parent to recover for their child's medical expenses, and we've interpreted it to say that the defendant, the tortfeasor, has to have caused the injury to the child, and under your theory, this child was born with conditions that were not caused by the doctor. So how do you get around Rule 1.206?
Rule 1.206 is an opposite to our factual situation. It applies to instances where negligence caused harm to a minor and enables the parent to sue in these instances. We're suing for the harm to the parents. The child is not the injury. The injury is the deprivation of the opportunity to terminate the pregnancy, and the foreseeable consequences that naturally and directly flow from that are the extraordinary expenses and other burdens that Mr. and Mrs. Plowman have to incur and experience. Again, why? Because the physicians didn't properly convey information to them so they could make an informed decision. That's all.
Do they have a legal obligation to support their son after the age of majority?
Yes, Your Honor.
And your source for that?
My source for that is the common law of this state, in which, in the Jacobs case, I believe, cited in the brief, which indicates that the duty to support extends as the need. Now, there is a case that was cited by the defense involving a 19-year-old who was injured, and the court found there was no duty on the parents to support the 19-year-old. But that 19-year-old had already been emancipated and living on his own. My client is never going to be emancipated. My client is going to spend, or my client's child is going to spend the rest of his life 100% dependent on others. He's never going to be able to care for himself, is never going to be able to earn living, one of two things going to happen. Either the legal system is going to operate and provide his parents with the damages so they can meet their obligations to their child, or the child's going to become a ward of the state at some point. As a matter of public policy, what makes more sense? To hold a wrongdoer accountable, someone who has purchased insurance, who is culpable, who did not adhere to the standards required of their own profession, and hold them responsible for the logical, direct consequences of their negligence? Or to leave a child without sufficient funds, without ability, because the parents don't have the money. Why don't they have the money? Because they were denied the opportunity to avoid this in the first place. The defendant argues that the number of states that have barred this cause of action by statute reflects policy. And I suppose it does reflect policy in those states, but has no bearing on the common law issue before this court. Of course, the Iowa legislature could act, if it wanted to, and change the opinion of this court. The defendant argues that this would somehow or another be a blight on the rights of the disabled and that children can understand litigation. That hasn't seemed to be a big issue in the other states where this cause of action is allowed. I don't think there's any data whatsoever showing that handicapped individuals are being hurt by the fact that their parents had a cause of action of their own, and through that cause of action are able to provide quality care to them for the rest of their lives. I think that type of an argument that, oh, you can't allow this because it would stigmatize the handicap is specious. What is more loving and dignified than to recognize that these parents have a tremendous financial obligation to their child because of another's negligence, and empower them as their own right because they were negligently injured to care for their child properly.
You may sum up, Mr. Willoughby.
I'm going to sum up largely where I began, without going through the litany of what this case is about, but to focus in for the last time, because I'm a broken record at this point. This case is about this court choosing to follow the laws of medical malpractice, to require doctors to adhere to the standard of care demanded by their own profession, and to hold them financially accountable for the harm they've caused when they choose, either through sloppiness, inadvertence, or for any other reason, not to do what they were taught to do, not to do what they were trained to do, not to do what they were supposed to do. My clients are here seeking justice for them and vindication of their rights and the harms they suffered and the burdens they now face because of malpractice. Thank you.
Thank you as well, Mr. Willoughby, and again, thank you, Ms. Penner. The case of Plowman versus Fort Madison Community Hospital is then now submitted